I'm trying to connect the facts. It doesn't make sense if there was no fighting, if there was no negativity, if nothing occurred, and all of a sudden some beautiful black curly hair and huge, delicious looking cleavage, and a statement is made that the woman would go and all of a sudden go home and nothing else occurred. She would grab a .22 and shoot herself in the head in front of her significant other without a statement made. All right, okay. We will go on the record in the matter 20.
Let's pause here. A woman ends her life, supposedly without provocation, and the defense leaps straight past motive. Isn't that the first thing you'd want to establish in any suspicious death? Ask yourself what's being brushed under the rug here.
53 CF 213, State of Wisconsin versus Bradley Scheuer. This state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Scheuer appearing in person in custody with counsel Glenn Keene. We're set here today in this matter for a sentencing hearing after revocation. Mr. Scheuer was placed on probation after he pled guilty back on September 3rd, 2024, to one count of possession of a firearm by a convicted felon. 3 days after he was...
3 days. That's all it took. Courts don't grant probation lightly, especially for gun charges. But when someone fumbles that lifeline immediately, the justice system starts looking less like rehabilitation and more like risk management. Can mercy be weaponized?
For another serious offense in which he was just recently sentenced. He was revoked on this matter due to the allegations and matters in the case that he was just previously sentenced. This matter was set for a revocation sentencing. The court has received and reviewed the revocation order and warrant packet from the Department of Corrections. I have reviewed such packet, and in my review, I could not see any material facts or statements that need to be clarified on the record. But again, I don't know all of the information that the attorneys know to be able to have those material facts and corrections jump out at me. Ms. Rockow, as Assistant District Attorney, are we in victims' rights compliance?
Yes.
Did you review the revocation order and packet in order?
I did.
Any material facts or statements that need to be corrected on the record?
No, Judge.
Is there going to be
no victim impact statement? That's telling. In cases involving trauma, silence from the victim's side isn't peace, it's either strategy, fear, or unresolved grief. And courts notice that kind of quiet.
Okay. Mr. Keene, did you receive and review the revocation order and recommendation packet?
Yes, Your Honor, and there are no facts in there that I believe need to be corrected.
Did you review that thoroughly with Mr. Scheuer?
Yes, Your Honor.
And he did not discover or find any material facts or information that should be corrected on the record?
No, Your Honor.
Okay. All right. Thank you. Ms. Rockow, please begin your sentencing argument and recommendation.
Thank you, Judge. The state respectfully recommends that Mr. Scheuer be sentenced to the state prison system for a total of 4 years, with 2 years of initial confinement, 2 years of extended supervision. That is in line with the recommendation that was outlined in the PSI by the department. As the court's aware, we are to consider the Galleon factors here in determining an appropriate sentence for Mr. Scheuer. The state's position is that Mr. Scheuer must be sentenced to prison based upon the factors. As far as the gravity of the offense, possession of a firearm by a felon is very serious. The legislature indeed has deemed this a Class G felony penalty of 10 years. It's a crime that poses a serious risk to public safety. This crime in particular, the underlying facts of this case warrant a prison sentence. Mr. Scheuer was, at sentencing, there were 4 other counts that were dismissed but read in, including 3 counts of possession of a firearm by a felon in addition to this conviction. There were 4 total rifles that were in Mr. Scheuer's possession at the time of this incident. And on the date of that arrest, he admitted, and in fact, one was in his direct control, very nearby to him, and he had admitted to law enforcement to having handled that firearm in particular on that date. He also had a knife concealed in his possession. So this is an inherently serious.
Let's break down Class G felonies in Wisconsin. We're talking up to 10 years behind bars. And this isn't just about a single illegal firearm. 4 guns, 1 within arm's reach, and a known violent history? That's not bad luck. That's a pattern one the prosecution is very comfortable leaning on.
Crime, and the facts are also quite serious in this case. In terms of the character of the defendant, again, inherent in this crime is an indication that the defendant has no regard for the law. He's a convicted felon, not allowed to possess firearms, and he did so anyway. His criminal history reflects convictions dating back to the early 2000s. He has a fairly extensive history. His history does include violent offenses, convictions for battery, domestic abuse, no contact orders, also includes recklessly endangering safety, and multiple convictions for bail jumping. I'll also note that there's a 2014 conviction out of Minnesota for possessing a pistol or assault weapon. The need to protect the public is the last factor for the court to consider, and I think that there's an obvious need to protect the public from Mr. Scheuer. A convicted felon with a violent criminal history who shows no regard for the law, no regard for court orders, or for the public, or for public safety. His actions that led to the revocation obviously include more violence, more disregard for public safety and for the law. I think anything other than a commitment to the state prison system would unduly depreciate the seriousness of the offense and the conviction here. And I do think, in fact, prison is necessary to protect the public in this case. Thank you.
A character witness for him. It's his son, Brandon Scheuer, who's here in court.
All right, Mr. Scheuer, you can come have a seat over at the black table, and you can state your name and spell it for the record.
Just be fast. Hello, you hear me? My name is Brandon Scheuer. It's Brandon Scheuer.
You may begin.
Where do you want me to start? Glenn.
Nope, you just...
Whatever you talked about.
Oh, whatever I talk about. Yeah. All right, well, I'll start.
Cue the emotional shift. Enter the son. And suddenly, we're not just dealing with a defendant, we're dealing with a grieving family, mental health battles, and generational trauma. But let's be clear, sympathy doesn't erase criminal liability. The court wants accountability, not just backstory.
Off by saying that, I do think that violent criminals should be in prison. I don't think my dad's a violent criminal. I think that he has mental health issues that were never addressed for the last 20 years. And I do believe alcoholism amplifies those. And I believe getting mental health would help him dramatically. In the case of this issue, I could tell my father was a different person after the suicide. My father always had like a clean counter, dishes always done, up early. I would not hear from him for a couple days after the incident. I would go check on him. He would still be in bed with a giant body pillow, counter trash, sink full of dishes, just completely not his character. And I believe that was just more depression. And I think that his depression and his mental health issues have never been addressed. and he's constantly been incarcerated and never gotten help that he's needed. And I think getting him the help he needs is a big step. Is he going to have...
That's the tone change. When a judge starts cutting through your defense with, "I've lived in bear country too," you know the excuses aren't landing. Legal mitigation becomes legal dismissal. And now, it's not just what the defendant did, it's how the defense tried to frame it.
I'm going to help him. He needs to get help. And I wish the court system would help more people in this case. It's an epidemic in this country where people are just locked away when they have issues, and we don't address the mental health issues that we need to address. 3 of those guns that were locked in the shed on the day of that incident were mine for deer hunting. I had them locked in that shed. I believed I had the only key to that shed. I was unaware there was a second key. The .22 firearm that was used in the incident, to my knowledge, was used for protection against bears as they were living in my camper on his 40 acres. When Crystal and my father first started staying on the 40, they were staying in a tent. They had had bears tear the tent, tear the coolers. I gave them my camper to stay in as a safety option. Other than that, the only real things I have to say is that I believe that this country has a problem with just locking people up and throwing them away. And I think that we need to address mental health issues more and more in this country. And this case in particular, he's had 20 years where he's never had that addressed. And he grew up at a time where when people had mental health issues, they really didn't talk about it or get addressed. And I believe most of his issues stemmed after the divorce with my mother in 2003. His alcoholism, which he hadn't drank in many years, had kicked off and came back into his life and continued to amplify those mental health issues. Because when people are depressed, drinking don't help that. All it does is amplify those issues. And that was never, ever addressed in over 20 years of him being in and out of the system. That being said, I can't quite think of too much other things to say. I know my father is a very good person when he's not drinking. He has donated his time to my business during the parades and other things, and to help me with working with kids in the community for kayaking. He cuts and splits wood. He has helped friends of mine who needed trees removed or other things on their property done come over without even being paid to help out, just to be a good Samaritan. So I know there's good in him. We're not unlocking the good. We're locking the good up with the bad. Where we should lock the bad up and unlock that good. And the only way that is to use, mental health therapy and other sorts of programs to get to the root of the problem. I went through therapy because of you, Judge, and I continue to do that therapy for a while after the things we had with the things I did to get back, and it helped me very much. I'm creating new programs to help myself hydrate more, things like that, getting better eating schedules, just slight things to add more consistency to life and a more routine schedule. And I think, that helps a lot of people. And it's something I needed just slightly to help my life. But there's a lot of people that need a lot more than that. And they need that intense mental care. And that's something this country has gotten far, far away from. And I hope we get back to it.
Thank you, Mr. Scheuer.
Thank you, Your Honor.
All right. Mr. Keene?